Participation Bill, second reading.
I call the Honourable Simon Power.
Mr Speaker, I move that the Court's Remote Participation Bill be now read a second time. Mr Speaker, this bill provides a legal framework for any participant in any court proceeding to appear by video link, provided certain criteria are met. I'd like to commend the Justice and Electoral Committee for its prompt consideration of the bill and for the sensible amendments it has proposed, which the Government supports. The committee received 8 written submissions on the bill and heard 1 oral submission. I note that some submitters and a minority on the Justice and Electoral Committee were concerned about the use of video links in criminal substantive matters where evidence is being presented. In particular, there was a concern that this legislation might be used to prevent a defendant from being physically present at his or her trial. Mr Speaker, I do not accept that allowing a defendant to be present at trial by video link is an erosion of his or her fair trial rights. Not to be present, I should say. A fair trial is about the ability for the defendant to participate in their proceedings. Physical presence alone does not ensure participation, and it certainly does not ensure effective participation. It merely provides an opportunity to participate. Under this bill, each case will be examined by a judge on its merits. In some cases, the judge may decide that the physical presence of a defendant will ensure effective participation. In other cases, the judge may find that a defendant can participate just as effectively by video link. Clause 5 of the bill sets out the criteria a judge must consider before deciding to use video link in any proceeding. Clause 6 of the bill provides even more safeguards if the video link is to be used in a criminal proceeding. In criminal proceedings, a judge will have to consider the impact of the use of video links on the defendant's right to a fair trial. Specifically, the judge must consider the defendant's ability to comprehend the proceedings, participate in the defence, consult and instruct counsel privately, access relevant evidence and examine witnesses for the prosecution. Where the judge is not satisfied that this criteria can be met through the use of audio-visual links, then they will not allow them to be used. Before this bill was introduced, it was reviewed by the Attorney-General and the Crown Law Office. The advice provided by the Crown Law Office, which is public on the Ministry of Justice website, was that the bill complied with the right to fair trial in the New Zealand Bill of Rights Act. In addition, each time a judge permits video links to be used, that decision must comply with the Bill of Rights Act. No defendant will lose the ability to participate in his or her own trial as a result of this bill. The safeguards in the bill ensure that the defendant's right to a fair trial is preserved. Equally, the rights and interests of other participants, such as victims and witnesses, can be taken into account in any decision to use video links. Video links can already be used for the evidence of witnesses, including the defendant. I do not accept that New Zealand is going beyond other countries in allowing defendants to appear at their trial by video link. Video links can be used in criminal substantive matters in New South Wales, Victoria and the United Kingdom. Bodies, in fact, such as the Yugoslavian War Crimes Tribunal have also recognised that there is a legitimate place for the use of video links at trial. I expect that there will be legitimate caution over the use of video links in substantive hearings. However, as the technology improves and the courts become more comfortable with it, this bill will enable video links to be used in a wider range of situations without the need for further amendment. I see no reason why the video links cannot be routinely used for the appearance of defendants in procedural matters. The use of video links in these situations is a sensible and safer response to significant court pressures. It would reduce the need to transport prisoners to and from court, which can have tragic consequences, as it did in the case of young Liam Ashley. The Ministry of Justice anticipates that by 2014, some of New Zealand's busiest courts could each see up to 2,000 remand prisoner appearances by video link every year. This represents significant savings for the justice sector and, I might add, speed with which these matters can be heard, without compromising the rights and interests of defendants. To bring it down to the level of an individual offender, in early 2007 it cost the taxpayer $16,000 or $4,000 each way to transport Graham Burton from Palermo to Wellington for 2 court appearances. I'm pleased that around $2 million will be made available in the coming financial year to fund the installation of video link facilities. I'd like to highlight 2 of the more significant changes recommended by the Justice and Electoral Committee. Clause 8 contains a presumption in favour of the use of video links in criminal procedural matters where no evidence is being presented. This presumption has been strengthened by the committee. This is an important point. While the use of video links remains properly at the court's discretion, Clause 8 now requires a judicial officer or registrar to consider using video links in criminal procedural matters if the technology is available. While video links are not entirely new to courts, this presumption will encourage culture change among the judiciary, court staff and court users to enable greater use of video links. We should not be afraid to use what is now well-established technology to help make our system run more smoothly. Video links may also be used in civil matters under Clause 7. This clause has been amended by the committee to ensure that the interests of other participants can be taken into account in any decision to use video links. For example, in custody proceedings in the family court, although the parties may consent to the use of video links, the child is not a party to the proceeding. The amendments to this clause ensure that the view of the child about the use of the video link can be taken into account. Once again, I thank committee members for the work they have done on this bill. I know they applied themselves in a rigorous way to many of the issues that were brought up during the hearings and evidence that was presented, and the House and myself are grateful for that. Mr Speaker, I commend this bill to the House.
Questioners, the motion be agreed to. I call the Honourable David